Estate administration can feel overwhelming, especially when you're grieving the loss of a loved one. But understanding the process can help make it a bit more manageable. Hi, Nancy Beaubier here with Agape and NEXsteps. And this week I wanted to talk about estate administration and help give you some pointers that will make it a little bit less overwhelming. First of all, I wanted to talk about what your responsibilities are as the executor of a will. This includes handling financial matters, legal matters, dealing with beneficiaries, and distributing assets. Now, if there is no will, and there has been no executor named, typically the courts will assign an executor, which is usually the next of kin. But do be aware that if there is no will and your loved one has died intestate, that this whole process will be delayed and can be more costly depending on if there's any disagreement among the next of kin about who should be named as the administrator of the estate. Now, if you are the executor of the estate, there are a few key things that you should be aware of that you will need to do. You'll be responsible for locating and protecting the deceased asset. You'll also have to pay any debts and any outstanding taxes. You'll be responsible for distributing the estate. And of course, that will involve communicating with the beneficiaries. And of course, you have to file all the necessary paperwork. So what are the first things that you need to do after your loved one has passed away? Well, you'll have to obtain a death certificate. That death certificate is going to be required by all financial institutions, any government agencies, and it will also be necessary for any insurance claims or any investment products that will be eventually passed on to either beneficiaries designated or to the estate. You'll also have to locate the will and the estate planning documents. Hopefully, if you're named as the executor, your loved one has already shared this and it won't be difficult for you to obtain these documents. One of the main things you're going to be responsible for as well is to make sure that you are securing and protecting any of the assets of the deceased. This will include things like any real property, any homes, any vehicles, bank accounts, taking care of any online accounts that the deceased had, etc. You'll also have to notify the key institutions. Now that will include banks, financial planners, government agencies, etc. Many times the funeral homes will assist with this paperwork and will submit it on your behalf. Something that a lot of people don't think of right away is to cancel any outstanding bills, any subscriptions. If somebody had, for instance, I know that we don't typically have newspaper delivery anymore, but if you had something that was being delivered to the home, that would have to be canceled. You'd have to put in a change of address to the post office so that there's mail not being delivered to the home address anymore or to the deceased, but rather that it's coming to you as the executor. Now, another thing that you need to understand is probate. One of your first questions may be, do you need to apply for probate? Well, the answer to that is it depends. It depends on where the deceased lived at the time of death, and it often depends on the size of the estate. When it comes to probate, there are thresholds typically about what is required for probate. And just to remind you what probate is, it is when the courts actually validate the will, claiming that you're the executor. Now, a lot of people don't like to have to go through probate, but it can be beneficial because it does actually legitimize the executor and recognizes their right to act on the behalf of the deceased. But the issues with probate is it can take a very, very long time. Typically, in any jurisdiction in Canada, it is taking anywhere from a year to 2 years and more, depending on how complicated the estate is. So more often than not, it's not to avoid probate fees that people are looking to avoid probate. It has more to do with the length of time before assets can be distributed. Generally speaking, what must go through probate are any assets that are in the estate. any bank accounts that didn't have a joint with right of survivorship on them, anything that did not have a named beneficiary. And typically what will avoid probate is any investments, any insurance products, any property, anything that has been designated a beneficiary, a named beneficiary. Now the next thing that you have to do is you have to manage debts and taxes. Usually what you will do is you will post a notice that gives creditors a period of time that they can come and make a claim against the estate. So you should be aware as the executor, hopefully, of any outstanding debts that the deceased may have had so that you can cover those off. Now the other thing is making sure that you file the taxes and pay any taxes that are due on any of the assets in the estate. You will have to file the deceased tax returns, and that often includes a final tax return as well as a tax return for the income in the year of death. And my suggestion is make sure that you don't distribute anything until you have the clearance certificate from Canada Revenue Agency. One of the things that you're going to have to do is deal with the beneficiaries. Trying to communicate openly with them, keeping them advised of timelines on dealing with the estate will work in your benefit. Beneficiaries most times don't understand how long this process can take, and most people typically think that once somebody has passed away, if they're going to be a beneficiary or an heir that's named in the will, that they should have access to that immediately. Unfortunately, it doesn't work that way. You're going to have to wait based on law and based on protecting yourself as the executor on how quickly you can distribute those items. Now, typically what you have to do is after you receive grant of probate, which can take 6 or 8 months to obtain a grant of probate, sometimes even longer. Once you have obtained the grant of probate, then in many jurisdictions, you still can't distribute any assets from the estate until a minimum of 210 days has passed. So now all of that has happened, and now you're going to close the estate. So what does that involve? Well, once the debts are paid, taxes are paid, you've got the clearance certificate, then you can start to distribute the assets to the beneficiaries and the heirs. Anything that has passed outside of probate will have already been distributed, but now we're down to things that were in the estate, including personal effects of the deceased. You're going to want to provide a final accounting to the beneficiaries, and you're going to want to obtain a signed release from the beneficiaries that removes any future liability that you will have as the executor or could have as the executor. So in closing, I'd like to point out that administering an estate might seem simple at the outset, but it is a very big responsibility. It requires a big time commitment from the executor. It involves some knowledge of legal and financial matters on how to process this. You should be an organized and structured individual that can manage and document everything that you're doing. I have an article on my website that you can access that will explain some of these steps in a little bit more detail. I'd also like to mention that if you are dealing with estate administration, that I am a certified executor advisor and I'm here to help. So just reach out for a consultation and we'll start the process. Thanks for watching. Don't forget to hit the subscribe, like, or share button, and also sign up on our website so that you'll receive notifications when we do post new information about your financial legacy and estate planning. Thanks very much for watching. Bye for now.